Yeah, so perhaps just on a personal note, I've been working on this issue for a number of years from an operational perspective. I used to work until recently with Médecins Sans Frontières and had collaborated closely with HPG on a number of issues, and HPG research interests were moving towards looking at counter-terrorism in more detail. So it seemed a natural progression for us to collaborate on this paper, especially with the 10th anniversary of the 9/11 attacks, of course. So I'm going to open just by running over the legal developments, so the legal context for this paper, which is essentially the first half of the brief for those who've already managed to see it. And then Sarah will continue to talk about the implications for humanitarian action in more detail and our recommendations for how to move out of, how to deal with some of these problems. So first of all, as a point of interest, there's no international definition of terrorism. One of the reasons why there's no international definition of terrorism is concern that anti-terrorist laws would be used against freedom fighters. So there's a debate within the United Nations about the right to self-determination and a concern that terrorism laws would be used against legitimate freedom fighters and rebels. The other is a controversy over whether terrorism can apply to state actors as much as to non-state actors or rebels. And basically these two issues have led to stalemate in international negotiations around treaties on terrorism, meaning that there is no global definition or treaty prohibiting terrorism. Within national systems, of course, if a terrorist act is prohibited, then it's properly defined. It would have to be under criminal law. And we can say that the main elements that cross-cut most definitions of terrorism are that there's politically motivated violence, that it causes death or injury, and that it aims not just to cause death or injury, but to intimidate a wider audience, and usually then to force some kind of political action. So those would be the common definitions, if we can find one at all. But the fact that there isn't an international definition of terrorism, of course, makes it more concerning when terrorism legislation is nonetheless introduced at an international level. It's more open to manipulation, and from the perspective of a humanitarian group, it's less clear what exactly is going to be prohibited. Okay, well, if we look at what exists generally, within the UN, as I said, there's no global prohibition of terrorism, no terrorism convention, but there are various piecemeal conventions prohibiting particular terrorist acts, which are not necessarily defined as terrorist, but by that I mean hijacking of aircraft or use of nuclear material and so on. Within different countries as well, the evolution of terrorism laws has taken trajectory defined by their own political history. So in the UK, of course, the evolution of terrorism legislation has very much been driven by the situation in Northern Ireland. So it doesn't start with 9/11 by any means. And in the US also, which we pay quite some attention to in the paper, terrorism laws dealt with domestic terrorism, such as the Oklahoma bombing, and then later were modified to deal with the attacks on the US embassies in East Africa in the late 90s. Nonetheless, it's clear both at international level and at national level that 9/11 does indeed mark a particular leap forward in counter-terrorism laws. At the international level, the Security Council passed a resolution straight after the attacks of September the 11th, obliging states to take a number of measures to combat terrorism. So this was a resolution, it's Security Council Resolution 1373. It obliges states, Chapter 7 resolution, obligatory to take a number of measures to prohibit terrorism. The most relevant ones for humanitarian action are about making sure that nobody in their jurisdiction contributes or provides resources to any terrorist group. But it's far more wide-ranging, of course, involving judicial cooperation and other mechanisms of interstate anti-terrorist work. Security Council Resolution 1373, being obligatory, is then incorporated in national laws, or existing national terrorist laws are modified to make sure they come into line with 1373. The EU, for example, also adopted a framework convention as part of its implementation of that. And the states that we examined in the paper, as well as others, have modified their laws. I'm just going to pick out the highlights of what parts of this law are relevant for humanitarian actors. So as well as the implementation in laws, you have the development of consolidated terrorist lists, so lists of people who are going to be prescribed under the national and international laws. Now, many armed opposition groups working in the kind of areas where humanitarians are active and individuals will appear on these lists. It's interesting, you were saying at the beginning how the debate used to be about funds getting to rebels. Essentially, it's the same issue that's been rebranded as a terrorist problem. So the same issue that humanitarians have always dealt with, about how to avoid diversion of funds and how to deal with rebel groups, has now been rebranded as terrorism, but with this additional threat of criminal sanction, which is quite alarming for humanitarians. So material support is the term generally used. Material support to any of these groups and individuals is criminal. And the definition of what material support constitutes is very broad. I think it's quite clear to everybody that participation or support to a terrorist act would naturally be a crime and not something that humanitarian organisations are trying to be involved in. But the breadth of the definition of material support means that humanitarian organisations fear that they could inadvertently contravene this law through normal humanitarian practices in the field, logistical arrangements for distribution of food and medicines and so on, for example. Another aspect of these laws which makes it particularly worrying for humanitarian action is the intent that's required to make any kind of contribution of crime. In general, it varies, of course, between the different states, so I'm generalising a bit, but in general, no intention to actually support an act of terrorism is required to fall foul of these criminal laws. Now, in general, under criminal law, to commit a crime, you have to intend to commit the crime. Now, the law won't necessarily say you have to prove that somebody intended. It will tend to say that you need to show that this person knew their acts would contribute and that they nonetheless went ahead and provided support. Now, that standard is higher than the standard that applies in most terrorist legislation. So, for example, to pick out a couple of examples we used in the paper, in the UK, if you have reasonable grounds to suspect that your actions might have contributed to terrorism, you will be liable. In Australia, if you're reckless means that you didn't consider whether it would contribute or not. And in the United States, as I'll look at briefly in a second, actually you don't even have to know that your support will contribute to a terrorist act if you know that it has gone to a prohibited group. Now, that might sound reasonable until you transport yourself into imagining humanitarian operations. So a humanitarian organisation may not have considered whether or not its distribution of food, its building of shelter, its running of a feeding centre was contributing to terrorism or not, because it's the programme that they've been running in the way they've been running it with the safeguards they've instituted for a number of years. Nonetheless, under current law, it might be that if any of those resources were to find their way to a prohibited individual, that they would be somehow criminally liable. That at least is the fear that humanitarians have. And to emphasise the fact that even humanitarian resources can constitute material support, I thought I would just look closely at, or a bit more closely, at a couple of cases that have come out of the US. The US law is without a doubt the most worrying for humanitarian organisations, and in general it applies extraterritorially, and also to citizens who are not citizens of the US. In other words, the fact that it's United States law does not limit its application to acts committed in the United States or by United States citizens, so it's relevant to all humanitarian organisations. The cases I was going to refer to are, first of all, a Supreme Court judgment that came out last year in 2010 and has been widely covered in the humanitarian sector. And that was the case of Holder versus the Humanitarian Law Project. Now, this is important particularly because it's a case from the US Supreme Court, so it's the first time that the Supreme Court has been able to pronounce on this law. It actually was not a prosecution, but a judicial review, so a case brought by the Humanitarian Law Project and some other organisations in order to ask for advice on whether their activities actually could be illegal under this material support statute. So the Humanitarian Law Project is involved in training and provision of expertise to two banned groups, the Tamil Tigers, LTTE, and the PKK, the Kurdish Liberation Party. And the Supreme Court found that training, the kind of training they were giving, was training in international humanitarian law and peaceful dispute resolution. And the Supreme Court found that this would constitute illegal material support because these groups were on the banned list. There was no question that the motives of the Humanitarian Law Project were entirely innocent. And clearly the type of assistance they were giving also was innocent type of assistance, but the court held that that was irrelevant. And in fact, there's this one quote I put on the slide. They said that even material support meant to promote peaceable, lawful conduct can be diverted to advance terrorism in multiple ways. So that sent a shiver through the humanitarian community. However, that applied to education and training. It wasn't specifically on the point of life-saving humanitarian goods. So perhaps it still remains to be clarified by the US courts whether the provision of some life-saving goods in any event would contravene the law. Now there is an exception in the US law for material support, which is limited to the provision of medicine and religious materials. And in the two cases of Shah and Farhane, the court was able to examine whether provision of medicine contravened the material support statutes. This was the case of doctors who had treated Al-Qaeda fighters. And, you know, extremely worryingly, the treatment of Al-Qaeda fighters was found to contravene the material support statute. So the medical treatment was material support to a terrorist group. Now, medicine itself is accepted in the law, but the court found that the provision of medicine did not extend to the provision of medical expertise, which was included in medical treatment. So, I mean, how you provide medicine, you know, if you're not a doctor and you provide medicine, maybe you'd be okay. Just a brief aside, that is a contravention of a very fundamental principle of international humanitarian law, which is that all sick and wounded have a right to medical treatment, and without any distinction. And medical treatment can never count as support to a party in a conflict. So that was disturbing. However, on a more positive note, perhaps, the courts did indicate in both of those cases that were it to be a situation where an independent, and probably well known, though they didn't say that, humanitarian organisation had been providing medical treatment, their decision might have been different. These cases concerned individuals who also professed allegiance to Al-Qaeda. So they were doctors who had voluntarily gone to work with Al-Qaeda, according to the court's judgment, in order to further the cause of Al-Qaeda. The principle is the same. I mean, it still should not be, according to IHL, it should not count as a criminal act, but nonetheless, for humanitarian organisations, there were indications in the judgment that it would have gone a different way if it had been a humanitarian organisation. Should I hurry up?
If you could.
Yeah, okay,
Sorry.
very briefly then, just to say there was one other case that also supported this, Boehm and the Holy Land Foundation, and if you want more details, they're in the report. Now, this threat of criminal action has had a big impact, as Sarah will talk about. The threat of criminal action. The actual prosecutions have been few, and have targeted Islamic organisations, so they have had a greater impact on that sector, and we'll hear about more of that later. But there are also effects on donor policy which resulted from this legislation. So donors implementing the laws have included clauses in their grant agreements so that a humanitarian organisation to receive money must certify that it will not support terrorism, etc. Again, it may not seem objectionable, but if you remember that humanitarian organisations are operating in a context where the terrorists are actually groups that they have to deal with for access to populations, aligning themselves with the other side can prove very problematic. The partner vetting system at USAID and some measures introduced by AusAid in Australia also oblige humanitarian organisations to report on the people they're dealing with in the field, and especially if they suspect that they might have any links to a banned group. And yet again, that puts humanitarian organisations in a very difficult position when they're trying to maintain a position of neutrality. And I think I will leave it there and hand over to